Item number 50, Your Lordship.
15.
Lordship.
15.
50, Lordship. After a week, Your Lordship. And for the appellant, Your Lordship. 50, 50. Fifty 51. Yeah. Date may be fixed. Next week. Any date may be fixed, Your Lordship. After 20. 23rd. Obliged.
May I please, Your Lordship? You consent from the other side, my lord. My counterpart, I beg to mention item 57 of supplementary list, my lord. And my come up after 2 weeks, my lord. As the Lordship was pleased to pass an order, stating that my counterpart will supply the address of the respondent, my lord. That's why he is not able to.
For petitioner.
I'm for the appellant petition. Obliged, Lord. May it please, Your Lordship. With the consent of the other side, my lord, I beg to mention item number 3. I am for the respondent. I have taken the consent of the appellants, my lord. Item number 3. I am praying that may taken after 2 weeks, my lord. Right. 3.
Item number 39, my lord. 1 week time, my lord. I have taken consent from the other side.
Obliged.
Right, please, Your Lordship. Lordship, I'm praying for listing of a BA, my lord. Earlier rejected by Your Lordship, my lord, for Monday if possible.
Lordship,
5. 5. Do you want? When do you want? Use the mic, I cannot hear you. To deduct it like
May please, Your Lordship. Lordship, item number 14. I'm praying for matter maybe taken up after 2 weeks, Lordship.
in.
Obliged.
I beg to mention item number 24.
2-4. Yes.
Time may be granted, Your Lordship, to file our substitution.
May I please, Your Lordship. Mention item number 56, order matter, Your Lordship. In this order dated 21/20, I may file an additional affidavit, but that has been not filed yet. So I may allow 2 weeks.
Yours says 56. Your
Your
item?
Lordship, 58.
58. For
I respond any. Sorry, appellant.
For
Appellant,
appellant, Lordship, in the
2 weeks time to file what?
Additional affidavit. So obliged.
May it please, Your Lordship, my lord. The second application, may I pray for the up-to-date LCR to be called for, my lord? And notice possible.
Oksho case, Lord.
Dated Scan copy of TCR. It,
Oblige, my lord. Ali, oblige, my lord.
May I please. Second anticipatory bail application filed before this court. By order dated 8/1/2026, your lordship was earlier pleased to reject the bail application, your lordship. Rejection order, your lordship would find at page 19.
new circumstances come now.
Lordship, basically, we have taken a plea of alibi. In the context, your lordship, if your lordships come to annexure 3 and 4,
That has been dealt with paragraph 7 of the order.
lordship. Moreover, they are not your lordships affiant and accused. If your lordships comes to the
Can't keep
FIR,
coming back. Go and surrender.
we will appear, your lordship, if the case diary may be called for once. Meanwhile, we'll appear, your lordships. We are not willing to
We
abscond.
waste our time. We have seen the case diary again and again.
They're not even FIR named accused, if your lordships comes to the FIR. Only one person has been named in the FIR.
We negotiate every time on the same facts. Where was duly perused? I think one was granted bail.
Yes, your lordship.
Rest were rejected because of the material available.
Once the case item will call for subject to your lordship's convenience, will surrender.
Yeah,
Your lordship.
we're stopping you from appearing. Had learned counsel for the petition, learned addition. Pre-arrest bail application filed by the petitioners, namely for the petitioners 21. The earlier order dated 08/01/26 passed in AB 2885/25 is clear that after perusal of the case diary and finding sufficient material against the present petitioners, also the view that custodial interrogation of the petitioners is necessary. This court has rejected the prayer for pre-arrest bail. Present application. Consideration of the case diary in the above the instant application stands. This
Obliged.
Yes, they are on interim, but CD not available. Yes, 18 lordship. They are on interim lordship. CD is not available. We need to call for the CD lordship.
question is this.
Brief.
Lordship on 13/11/2025, they are
Here's for the petitioner. Perusal of the order sheet revealed the CD was first called for 30/10/25. The date for production of the same was 13/11/25. Thereafter, was fixed on several dates, but the IO failed to submit the CD. Last opportunity is granted to the IO to produce necessary action. Still yet to continue in the next.
So the AB application was the second time, my lord. Perhaps CD has not been received, my lord.
Your Lordship, the service also completed, Lordship.
Service is completed on the informant respondent number 2, my lord. Storage of 19/2, thereafter on 25/2, CD was called for, my lord. Occasion earlier. Has to come from, my lord, Howley PS. Peta district.
Completed.
Yes.
The notice issued here is completed, Lordship.
Current counsel for the petitioner. Additional PP submits that notice and respondent number 8. And so is appointed as amicus to represent. Not been reached.
Can it be on 13 or 16? As per 16. Both are same, my lord, 19 and 20, connected. My lord, order may be passed as regard to the, my lord, up-to-date CDC, since incidences of 21/6, my lord, 25.
Let's release the for production of up-to-date CD.
Highly blessed, my lord.
I am appearing for respondent number 1.
Your Lordship, may I plead?
There is an IA, no copy served to me, Lordships. First appeal of appeal, Lordship, fine. Received, but what is
Your Lordship, may I plead, Your Lordship? Your Lordship, I seek some passover for the time being as my senior is kindly coming.
Therefore, respondent
1, Lordships? There is an IA also, I do not know.
Your Lordship, I was order 39 rule 1 and 2, so I will serve.
where is the IA?
I am ready.
Section was for registered post ID. Service is not complete otherwise. Okay. All right, since you have appeared. You survey me a copy of the I. Hard learned counsel for the petition. So heard Mr.
A few word, yeah.
Respondent number 1. It is submitted that P of the IA 2923 has not been received by him. Same be furnished in the course of the day. Is the matter again on? Interim
Right.
order passed earlier.
21 loss,
Your lordship, one more prayer I have.
25th of March.
Your lordship, may I please? Your lordship, we have an interim, we would like to extend the interim.
To continue.
Obliged.
None appears for the appellants on call. Or that on the previous date also. Appeal stands dismissed for.
My lord. Against the judgment and decree dated 25/7/2020 passed by the learned civil judge at Gauhati. My lord, the suit was filed for declaration, partition, and recovery of possession. The defendants had filed.
Speak a little louder.
My lord, the defendants had filed a counterclaim for specific performance of contract, my lord. My lord, basically, the predecessor in interest of the plaintiffs and defendants in common had was the absolute owner of a plot of land measuring 3 bigha 3 katha. Subsequently, my lord, he had 3 sons, and the entire land was divided equally amongst the 3 sons, 1 bigha 1 katha each. Subsequently, my lord, in the year 2012, the defendants had approached the plaintiffs to purchase their share of land, and they had agreed upon a consideration price of 30 lakhs per bigha, my lord, per katha of land, my lord. Subsequently, my lord,
Yes.
yes, my lord, subsequently, the defendants had failed to pay amount, my lord. This agreement was executed in the year 2012. During that time, they had paid an amount of 7 lakhs, my lord, and subsequently another 5 lakhs was paid. However, in the remaining 8 years before filing of this suit, they had not paid the entire amount, my lord. The learned trial court below had held that my lord, the learned trial court below had partly allowed the counterclaim, my lord, stating that the amount of 12 lakhs be returned with interest to the defendants. However, my lord, the learned trial court below had failed to consider certain aspects of the matter. My lord, the grounds are at page number 4, more particularly ground number 4, my lord, at page 5. If I may read, my lord, for that the learned court below completely gave a wrong finding in holding that the counterclaim filed by the respondents is not barred by law of limitation. A bare perusal of Exhibit B and its stipulations would clearly go to show that the payment of the advance consideration amount by the predecessor in interest of the respondents, the remaining balance sale amount would be paid immediately after execution of Exhibit B. The respondents neglected and failed to take any steps to pay the remaining balance amount after payment of the initial advance amount of 7 lakhs. The Exhibit B and C, that is the agreements for sale, were executed on 6/6/2012 and 6/11/2015, and as such, the respondents ought to have filed a suit for specific performance of contract on or before the year 2018. That is within a period of 3 years as stipulated under the law holding the field. However, the respondents have filed a counterclaim in the year 2022, that is beyond the period under Limitation Act, for enforcing specific performance of contract. The court below completely failed to take into account the aforesaid aspects of the matter, which goes to the root of the list, and as such, the impugned judgment and decree dated 25/2/2025 is liable to be set aside. Round number 5, my lord. For that, the learned court below completely gave a wrong finding in deciding issue number 6 of the counterclaim by holding that the appellant number 1 is liable to return back the advance amount of 12 lakhs at 6% per annum. The learned court below, while coming to the said conclusion, completely failed to take into account that as per agreements for sale dated 6/6/2012 and 16/11/2015, that is Exhibit B and C, it is specifically stated that the respondents would pay the balance sale consideration amount immediately after execution of Exhibit B in the year 2012. The respondents till date has not taken any effort to pay the said balance consideration amount, in spite of time being the essence of the contract, and on the contrary has been enjoying the entire Schedule A property, including Schedule B property and its usufructs, by earning handsome amounts as rent from monthly tenants. The appellants have been deprived of their ancestral property, that is Schedule B. My lord, Schedule B is the share of the plaintiffs, my lord. Property from the year 2012, just because of the illegal and malicious attitude of the respondents. The learned court below, considering the facts and circumstances of the case, ought to have passed a decree granting mean profits in favor of the appellants. However, the learned court below, on the contrary, has directed the appellant number 1 to return back the advance amount with interest, which is not at all sustainable and tenable in the eye of law. And as such, the impugned judgment and decree dated 25/11/2025 is liable to be set aside and or reversed. My lord, there is another appeal, analogous appeal. This is against the counterclaim, my lord, partly decreeing of the counterclaim. My lord, against the dismissal of the suit, there is another appeal, my lord, that is 18/2026, and that was admitted by the Honorable High Court by order dated 25/2/2000. The records have been.
This is against what?
This is against the partly decreeing of the counterclaim, my lord.
Yes. And the other end was against the dismissal of the
Dismissal
suit.
of the suit, yes.
Why are they not together?
My lord, due to some defects, my lord, they were not. I pray before your lordship that the matters will be tagged together. For
When is it listed?
my lord,
When is it to be listed again? Any date has been fixed?
my lord, that is not specified in the order, my lord.
All right, heard learned counsel for the appellant. It is submitted that
8/4, no?
connected appeal being
18/2026, my lord.
RFA.
Yes, my lord.
6 is pending, and both are required to be tagged together, hence list the matter along with RFA. Then give a date.
My lord, if I may, my lord, the other appeal is fixed on 8/4/2026.
8/4.
Deeply obliged, man.
First appeal against the judgment and dated 6/8/2024 in title suit number 17 of 2017.
Because of my poor health condition, I could not prepare. Can it be on Monday, my lord? I could not prepare the case, my lord. I'm preparing for the sole respondent, my lord. Can it be prepared listed on Monday, my lord?
No, your lordship, there is the execution proceeding is going on expediently. So appeal admitted, ground stated in the page number 3, your lordship, kindly. Relevant bill is page number 3. Learned trial court get back his earnest money, and accordingly the appellate defendant is directed to refund rupees 10 lakhs only received by him from the respondent plaintiff as earnest money along with interest at the rate of 6% per annum from the date of institution of the suit till realization within 3 months. Next is decree that the respondent entitled to cost of the suit without going through the record of the case, that the respondent plaintiff nowhere in his plaint as well as in his evidence whisper a single word or adduce any documentary evidence to prove that the plaintiff respondent has paid an advance amount of rupees 10 lakhs to the appellant and the learned trial court without going through the documentary evidence amounting legally decided. Number 4. For that the respondent plaintiff has filed the suit for specific performance of Contract Act by number dated 24/3/2017, Exhibit 2, and said Bainama is not registered as provided in Section 53A of TP Act, and as such the agreement Bainama dated 24/3/17, Exhibit 2 have no effect in view of Section 17 of Registration Act 1908 and Section 17 Registration Act provided Bainama shall be registered 1 and the learned trial court without considering the said provision of Section 17 of Registration Act may illegally decided. For that, number 5, for the respondent plaintiff has not registered the Bainama dated 24/3/2017 as required 17 Act. Since the value of the property mentioned as rupees 24,50,000 and respondent plaintiff filed the suit against the appellant defendant on the basis of unregistered Bainama, and the learned trial court could not consider for that respondent purchased the stamp paper on 28/2013 and the alleged Bainama was executed on 24/3/2017 after 3 years and 7 months. And the respondent plaintiff has not explained or clarified why the predated stamp paper is used in Bainama dated 24/3/2017 and the Bainama dated 24/3/2007 has been tempered overwriting by the plaintiff, and as such the same is not tenable in law. Second, appellant before the competent authority Deputy Commissioner Hailakandi for transfer of the suit land tracker without considering the said fact illegally decreed in favor of the. Number 4, appellant 30 to the plaintiff responded nor execution any Bainama on 24/3/2000 in favor of plaintiff respondent, but the respondent plaintiff with the intention to grab the landed property obtained certified copy of so and so and prepare false agreement to sale of the land so and the learned trial court without going through the said illegally decided. For that, any number 9. For that, any transaction up to 20,000 may be made in cash. Beyond rupees 20,000 transaction should be made in check, online, demand draft, etc. But in the present case, the respondent plaintiff paid 10 lakhs in cash at advance to the appellant, as stated in agreement dated so and so. The plaintiff respondent has not adduced any documentary evidence in this regard, and the learned trial court without considering the same. For that, respondent plaintiff have not explained anywhere in his plaint as well as somehow respondent evidence explain how respondent paid the consideration money of rupees 10 lakhs to the appellant for Bainama dated so and so. In his cross-examination, the respondent plaintiff stated that only respondent plaintiff withdraw rupees 1 lakhs from bank and rest consideration money amount from his friend Hassan Ahmed, Borbhuia, Bimal Das, and Aminul Islam, but nowhere stated from which bank respondent withdraw the amount, and said Hassan Ahmed Borbhuia stated his cross that he paid money to the respondent, but he cannot remember the exact amount, and there is no evidence how the respondent managed the balance money from the respondent. It is crystal clear that respondent is not able to pay the advance amount as Bainama dated so and so. Further, the appellant defendants never executed any agreement by Nanama dated so and so in favor of the respondent. Lordship, this is the main ground.
So deny execution of the agreement.
Yes, Your Lordship.
Is there to submit now. This is a statutory appeal. It has to be admitted.
Your Lordship, stay the execution proceeding kindly. There is an IA.
Learned counsel, appellant. So learned counsel appears for the sole respondent. Against the so and so. See the order date. Decree dated so and so. Learned respondent is represented. Counsel, no further notice is required. Pending. That execution proceedings have been initiated.
24 or 24. There is an IA 7/16/2025.
A separate IA has been preferred. Is the appeal again on so and so? IA 7. Applicant and learned counsel for the respondent. He has been preferred seeking stay of the execution. Of the judgment and decree dated 6/08/24 passed by the learned civil judge senior division Hailakandi in TS 70 of 2017. Where have you stated execution has been filed? Case number is there.
Oh, Your Lordship, 24 or 24 execution. X number 24 of 2024.
Where have you stated?
No, Your Lordship, I have not there that time I is not prepared. So this is the execution order dated.
Is submitted that execution proceedings being X 24 of
24 to 24. Certified copy of.
24. Senior division Agandi. the further proceedings in title execution case number 20. Will remain stayed till the next date. The matter again on so and so. In the meantime, you can appeal.
Please proceed. So this is an appeal against the judgment and award passed by the learned tribunal to be lordship. Appeal is for enhancement of compensation awarded by the learned tribunal. The claimant has suffered disability to the extent of 28%. And he lost his earning capacity, but the learned tribunal has not awarded any amount for loss of income. And on the other hand, amount awarded towards non-pecuniary heads are on the lower side.
Learned counsel for the appellant. This appeal has been preferred against the judgment and award dated so and so. So and so. The steps by registered post with AD within 3 days. Is the matter again on.
Record has been called for. Record has been called for. Yes.
Then appeal for enhancement. The issue notice PCR may call for us.
Same order.
Oblas.
Your lordship. So this appeal has been filed on the ground that insurance company has there has been a violation of policy conditions. So it's
You're appearing.
I'm appearing for the claimant.
Third learned counsel for the appellant. Here's for respondent number
1.
1. Any others?
So only
no,
to
no, just two.
only to respond.
Call for the TCR. Again on.
The petition for stay.
Where is that stay petition?
694.
Huh?
Memo of appeal may be served.
A copy of memo of appeal may be served upon the learned counsel for.
I'm willing to deposit 50%.
Once such deposit, we may be allowed to withdraw it, lordship.
Yes, 694 of 2026. Hard learned counsel for the applicant. Respondents, this IA has been referred. Stay of the impugned judgment and award dated 13/11/25 passed by the learned member MSCT Kamrup in MSC case number 241 of 2000. Regard to the averments aforesaid impugned execution. Order, it is provided that the appellant shall deposit what 50%? 50% of the awarded amount within a period of 4 weeks.
4 weeks.
Upon such withdrawal,
Upon such deposit, the number 1 may withdraw 50% of the deposited amount from the tree. I stands disposed of.
The deposit is not the 50% of the deposit. They will deposit the 50% of it. We will be allowed to withdraw the deposited amount.
Entire
50% will not. They are depositing only 50%.
which amount will be withdrawn? First is 50%. Okay.
I'm okay.
appeal has been filed basically on the ground that deceased was a retired government employee. He was 64 years old and his pension was 35,445. And that has been considered by the tribunal for assessment of loss of dependency. Honorable Supreme Court has said that wife will get the pension, so 50% may be considered as a loss of dependency. That is why main appeal has been filed. And claimant has filed the case under section 166, but claimant has not examined any eyewitness to prove rash and negligent driving. The appeal may be admitted, we will deposit 50%.
Same order, huh? Okay. Left deposit. Steps by. Is to the respondent, steps by. Get 50% of the ordered amount. We will not say about withdrawal today since he is not there. Let him come.
Steps may be usual process, Lordship. It is better service, not by Lordship a registered. Usual process is better, Lordship. It is court process. It is served easily.
Steps by usual process. Okay, instead of
obliged. Stay subject to deposit. Obliged.
Please, Your Lordship. MSC appeal, my lord, by the insurance company, my lord. Here, my lord, the ground is that, my lord, the deceased was traveling in a two-wheeler, my lord, as a pillion rider. The policy, my lord, of the vehicle, my lord, is to be a bundle policy, my lord, because this was a continuing policy otherwise, but the coverage for the pillion rider ceased to exist at the time of accident, my lord.
already had learned counsel for the appellant against the so and so. Steps by what? Usual process or?
My lord, both ways, my lord, both ways.
By speed post to AD as well as by usual process and within. All for the TCR. Ordered amount in a period of 4 weeks. Judgment and award shall remain pending deposit. Subject to deposit of the 50% of the awarded amount. Is the matter again on? I is there.
I is there. Separate I is there for.
I numbers. I stands disposed of in terms of order. First in MSC in the connected appeal 97 of 26.
Lord, my prayer is that deposited amount may not be allowed to be withdrawn without the leave.
We have not passed this date. Let him come and file application.
My lord. Much obliged.
Lordship, in this case, I mistake, Lordship, the check of statutory deposit, Lordship, 25,000 is not Lordship.
Can't hear you properly. Say again.
Lordship, in this case, Lordship, the check of statutory deposit of 25,000 is deposited before the registry, Lordship, at the time of filing the case. This matter taken after 1 week, Lordship.
The prayer of learned counsel for the appellant release the matter after a week on it.
In this particular case, Lordship, this was a government employee. He died at the age of 55 years. As per circular issued by the government 2017, family member will get full pension till date of retirement. Supreme Court in Texan has already held that they are not entitled for loss of dependency, except that they will get the entire amount, that is, Lordship, loss of consortium, that they will get. But loss of dependency, they will not get. That is established, Lordship. Texan Supreme Court has affirmed that.
Same order issue notice, usual process, no? Till you have to deposit.
You will deposit 1 lakh rupees.
What is the award? 2 lakhs?
No. Award is heavy loss, 42 lakhs. But if we deposit, they will pay for withdrawal of the amount. Generally, in this particular case, all these cases, court has directed only the consortium and the loss of estate and funeral expenses. That is 75,300. With interest, I am depositing 1 lakh. Similar order I can give, Lordship. All this court has given same order, only this amount.
Pass on. Same order. The date.
Apply those.
An MSC appeal by the insurance company, my lord. Here, my lord, 2 vehicles were involved in the accident, my lord. And the allegation was against us. A police case was registered against both the vehicles. And my lord, the charge sheet was laid against the other vehicle. So that fact was not brought into before the learned member MSCT, my lord. Thereafter, my lord, we filed a review application. Review application was dismissed. And during pending disposal of that review application, my lord, another 2 judgments have been passed by the same member, my lord. Thereby, in that judgment, my lord, liability was apportioned between both the vehicles, my lord. Lordship may kindly see the judgment I am referring to, my lord. Lordship will find at page 38. This is a subsequent judgment arising out of the same accident, my lord. Liability has been apportioned, my lord, between the 2 vehicles. Operative part, my lord, 44, my lord.
So what is wrong with that?
My lord, the finding is, my lord, subsequent finding is my lord, on both the vehicles, but the previous finding, my lord, is against us only. Of course, my lord, we could not bring the charge sheet on record, my lord, but the case was registered against both the vehicles. PCR may be called for, my lord. It may be admitted, my lord.
Yes.
The case of composite necklace. So,
Yes.
doctrine of the rest here is, I mean to say that the joint tort faces, it is as just what the vehicles are liable. So we have the option to file the claim of the vehicles or both of the vehicles. In this case, the lower court, the tribunal has well appreciated all the evidence, and it is a 1.5 decades. But at this time, this charge sheet has not been, they have got an ample scope, but they haven't exhibited the charge sheet, and haven't exhibited an eyewitness. We have everything has been taken into consideration. Judgment has been passed. And what the 2 cases are talking about, these are all the cases were taken to account independently, taking the circumstances. So I have this case where I don't have any contribution. So when it is a case of composite negligence, it's an interstate dispute or interstate adjustment. So I shouldn't suffer. Who am I? I am a widow, poor widow. I am a unmarried daughter, and I am an unemployed son. So I need this.
So they'll deposit.
Deposit 50%.
Deposit 50%,
maybe
my lord.
deposited.
Deposit 50%.
Learned counsel.
And with all greatest respect, this 50% may be allowed to the claimant to collect. It may be deposited of the claimant.
Let counsel appearing for the payment respondent number.
Respondent number
1, 2, and 3.
2 and 3.
There are total 3 respondents.
Respondent. Spouse, the
Claimants were
daughter,
3. One.
and the son.
Against so and so. Admitted call for the appellant awarded amount within a period of registry of the court. The are allowed to of suitable state subject to deposit of the awarded amount. The matter again on
But
you have order passed in with IS.
possible.
Please, my lord. My lord, this is a matrimonial appeal, my lord. My lord, divorce was granted on the ground of 20, my lord. I'm against that judgment. Appellant before your lordship is there, my lord.
Within time.
My lord.
Within time.
Within time. Judgment is passed on, my lord, 3-2, my lord.
You're for the
I'm for the
husband,
appellant, my lord. Appellant husband, my lord. There is at page 79, my lord.
You are against the divorce or against?
I'm against the divorce, my lord. Decreed, my lord. Suit, wife filed the suit for divorce, my lord, on the ground of cruelty. That was decreed, my lord. I'm against that judgment, my lord. Page 79 is the conclusion, my lord.
But you want to keep her by force?
I'm not for force, but my lord, the allegations is of cruelty, my lord, and that is not at all proved, my lord. On the basis of the statement of the my lord wife, the court has come finding that there is cruelty, my lord.
Heard learned counsel for the is directed against the side of a court. One respondent only, I think. Respondent steps by it post to it AD within 3 days.
It starts from page 39, my lord. Page 40, my lord.
That is all for now.
Lordship may admit the appeal, and my lord, there is one IA for a stay, my lord.
Please. That is, we have done already. Appeal is admitted. Can call for dissent. TCF.
There is one IA for a stay, my lord.
I-740. Let's learn it counsel for the applicant appellant. This IA has been preferred seeking stay of the impugned judgment and order dated 3/2/26, decree dated 7/2. The learned additional district judge FTC Assam, title suit matrimony. The contents of the IA as well as the appeal. Regard to the judgment and order degree state shall remain state till the next date of listing. Please.
Right.
You should notice steps by speed post.
Your Honor, the matter may be passed over for a time being as my senior is in another.
May I submit one thing? Against their IA application as well as they filed an affidavit in additional affidavit against those, we filed a written objection. So that is not tagged. So that is to be tagged. And if possible, that matter may be taken up tomorrow also.
Already on the last two occasions, they have already taken.
On adjournment, we have not taken. That this senior advocate, he was absent. So that may be taken.
Tomorrow, I don't think I have a bench. I don't have a bench tomorrow.
In the second half, the matter may be taken.
It can be taken up by any other bench also. But I can't fix it.
I am not on that. Let's say it may be taken on Tuesday because I will not be available on a Monday.
Submitted that written objection has been filed
Against the IA application as well as additional affidavit.
against the IA as well as additional affidavit has
Filed
been
by the petitioner.
filed. Who has filed the written objection?
Lordship, the respondent.
Against the additional affidavit.
Additional affidavit as well as the IA filed by them.
Submitted that written objection has been filed on behalf of the respondent against the additional affidavit as well as the IA filed by the appellant side, but the same is not able on record. Registry is dictated to place the same on record and leave the matter again on Tuesday.
Lordship, as per official dated 2/3/2026, service report is awaited, Lordship.
As per office note dated 26, AD card as well as service report in respect of respondent number 1 is awaited. And is the matter again on showing the name of learned counsel for the insurance company.
Is that we have about 478 days, Your Lordship. We have 478 days. Your Lordship, matter is not different, Your Lordship, because no surviving respondent is there, Your Lordship. Newspaper publications were also published, Your Lordship, none reported. And amicus was appointed by this honorable court from Jorhat, Sahewala. He also inquired and he could not also find any surviving respondent. On the amicus declined to continue as amicus, but then presently, Your Lordship, the case has to be proceeded as per order 22, rule 4A, Your Lordship. Because all efforts have been made, Your Lordship. And amicus was also appointed, and later on he declined. Therefore, it has to go by order 22, rule 4A, Your Lordship. And whatever order is passed will be binding on the suit property, Your Lordship. Therefore, Lordship may consider condonation of the delay without issuing notice, Your Lordship, because notice will serve no purpose, Your Lordship. It has been explained in page 4, Your Lordship, page 4 and 5, Your Lordship. Paragraph 4, 5, 6, 7, and 8. Actually, what happened during the period of filing this appeal, Your Lordship, the counsel who was conducting the matter, Your Lordship, he fell ill, Your Lordship, and was suffering from cancer, Your Lordship. Later on, he died, Your Lordship. Therefore, the delay occurred, Your Lordship, because of his ailment, Your Lordship. He was in Delhi, Your Lordship, for surgical operation, Your Lordship. The delay was caused, Your Lordship.
So some official has to be appointed to represent.
That was the effort was made, Your Lordship. But then
No, if we have to proceed under order 22, that is the procedure there.
what
is the you are the appellant.
I am the appellant, Your Lordship.
What is the judgment about?
That was a specific preference, Your Lordship, was there. Judgment is at page 22, Your Lordship, of the memo of appeal, Your Lordship. Paint is at page 9, Your Lordship. It starts from page 9. an agreement for sale and purchase of the land, your lordship, at a price of 97,000, and 40,000 was paid already, your lordship, and he was willing and ready to perform the rest of the contract, your lordship. Lordship, Rule 4A of the Order 22 says it can also proceed ex parte, your lordship. And whatever decision is arrived at by the decision of the court, that will be binding on the property.
Where is the judgment under challenge? Where is that?
That is 44, your lordship. That is the title appeal, your lordship.
না, এখন
And then present thereof is starts from page 46, your lordship. Title appeal.
for purchase of a land.
Lordship.
If there is no surviving respondent, who is the owner of the land now?
Lordship may issue a precept to the government, revenue authorities there at Gauhati, to accept the rest of the amount and register the suit land in the name of the appellant. If your lordship so decides, your lordship. Otherwise, it will go other way around. Because there being no respondent, they can enjoy the property, your lordship, but then title, they will not have the title, your lordship. That is why this has to come to a conclusion, your lordship. Either way, lordship.
Where is the report regarding absence of the respondent? What was her name? Bhanu,
Bhanu Day.
Bhanu Day.
Bhanu
Bhanu
Day
Day
died.
expired.
And they were instituted, Your Lordship, by the legal heirs.
What happened to those legal heirs?
They are there.
Huh?
Bhanu Day is there. Respondents are not there, Your Lordship. Bhanu Day is the
Bhanu Day is the appellant.
appellant.
Bhanu Day is there.
Legal heirs of.
No, no, what
that is
happened?
there.
Where is there any report regarding the status of the respondents that they have expired or whatever? What is on record?
Amicus only,
Huh?
Amicus only said that he could not find anyone, Your Lordship. Because we published newspaper advertisements, Your Lordship, but nobody appeared. From Gauhati also, in Janambhumi, advertisement was published, Your Lordship. Appellants are in possession of the land, Your Lordship.
All right, let us see. Only question is whether to appoint someone or to proceed expert. Both are permissible, but depends on the circumstances.
I decide.
Let me. If to appoint, whom to be appointed? To Chamber of Division.
Lordship may proceed expert also. There is the 4A allows that.
Yes.
Obligers.
Your Lordship, I have the instruction to withdraw this appeal measure.
All right. Sir, T. Kolita, learned counsel for the appellant submits that he has instructions to withdraw the instant appeal. Prayer is allowed. Appeal is withdrawn.
Sir, there is an interim order, my lord.
Interim order, if any, stands vacated.
25/7/19. And my lord, the deposit of 25,000, my lord, may be returned to us.
The
Statutory deposit, my lord.
statutory deposit already made is allowed to be withdrawn.
I'm appearing for respondent 1 and 2.
Appears for respondent now.
Noted at 24/4/26. Respondent number 1 has filed Wakalat Nama as per office note dated 2/3. I'm appearing for respondent number.
Office note dated 25/2/26. Yet to be affected upon the responder 8 full stop learned counsel
Finn does, Lordship.
Has entered appearance for respondent number 1. David. 228. List again.
My lord, may be possible today, Lordship. The Prakash is on lakhs in court number 19. May possible.
Your Lordship, in this matter, my humble submission, it has become in filing the review the order that was passed in the CRP. In the meantime, execution has already taken. Holder has taken possession of.
Maybe possible. He's on lakhs. We will submit, Lordship.
Respondent number 2, anybody? You are for 1.
Second, step for paper publications. File the affidavit. Completed.
You have submitted.
13/2/2026.
Learned counsel for the applicant and learned counsel. Respondent number 2 has by way of substituted newspapers, namely the Sentinel 6 and Barta. Along with the publications. Here has been received.
Yes, Lordship.
Huh?
Yes, Lordship.
Lordship, my humble submission, the appeal may be admitted for hearing, subject to payment of 50% at least.
It was not admitted earlier.
I has not filed for payment. There is no IA. We have not filed any IA.
Therefore, what?
For payments or release of the money.
Have you made deposit?
Sir, we,
Appeal is already admitted for hearing.
sir,
The appellant may be directed to pay at least 50%, Lordship.
For what? Enhancement? Oh, insurance is coming in appeal.
Lordship.
The appeal has already been admitted for hearing. Appellant is Assessment and awards. The amount,
10 lakh something, Lordship.
10,85,550.
such deposit being made in the out to withdraw. Who was respondent number 2?
And driver.
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 The same. Double bond. List the gain on.
Lordship, claimant may be allowed to withdraw the after deposit.
If that is what we have said. Respondent number 1.
Respondent number 1.
Obviously. Well, the IA is for condonation of delay in filing the MSCP appeal. Yesterday, they has filed their, respondent number 1 has filed his objection.
Lordship, I have filed my objection yesterday, Lordship.
Not now.
I think it is not in record, Lordship.
Otherwise, my lord, there is an order for pay and recovery. But initially, while the case was pending before the tribunal, my lord, owner and driver, both of them never received any summon. So, my lord, only after receipt of summon for recovery, my lord, then only he came to know in the year 2022 about the judgment. So that is my ground only, my lord. Earlier, my lord, I have annexed all the orders passed by the my lord, tribunal, my lord. Lordship, if your lordship kindly see, my lord.
You are the owner.
Yes, my lord, I am the owner. I have annexed the my lord, original copy, certified copy from page 33 of the tribunal, my lord. Case was filed on 7/8/2013. Page 33, my lord. Type copy is at page 29.
The objection come into record.
Objection is here.
Here.
He has filed new objection.
New
On
objection.
Number
Our
1,
objection is there.
history and providing.
I'm for 3 and
Or 3 and 4.
Yeah, I'm for 3 and 4.
Yours is not there.
Yes.
He filed yesterday, that's why it is not.
Submitted that an objection has been filed against the present IA on behalf of respondent number
1.
1. However, the same is not available on record. Registry is directed to place the same on record.
Next week, my lord.
Please the matter again on. He has given it.
Next week, kind. Huh? Yes.
Obliged.
Obliged.
May it pleases your lordship. Lordship, in this case, we have filed one additional affidavit, and that is marked as flag additional affidavit, lordship, with the newspaper publication, lordship, for respondent number 2. For 1, lordship, already it was received by his wife. Office note dated 25/11/24. And for respondent number 2, we have filed this affidavit, lordship, the newspaper. So the service is complete and TCR has come, lordship. Taken as served. And go for final hearing, lordship. Because it was admitted on 27/6/2020.
Counsel for the appellant. Two. By way of paper publication. Available on record. Yes, that notice has been. But newspaper. 18/1/20. have also been. What about one?
One lordship of lordship will peruse office note dated 25/11/24 for R1 received by wife.
Did
25/11/2024.
there has also all. Is it admitted already? Admitted. The hearing.
Next to move. Lordship, here lordship, I have three petitions for condonation of delay in filing the substitution petition, abatement, setting aside abatement and substitution. In lordship, analogous cases already they are allowed, lordship. I'm giving. (1061) is for delay substitution. 1062 is setting aside abatement, and 873 is for substitution, lordship.
Notice.
Notice, lordship, we have filed our affidavit, lordship. Additional affidavit is filed, lordship, in which we have given in the newspaper, lordship. Because, lordship, originally it was fixed for delay, condonation of delay. Then we came to know that they are the person dead. And we filed it, and the court ordered us to make newspaper publication. Basically, lordship, if these three petitions are allowed, then the case will go to the original EA of condonation of delay.
All the respondents are served by paper publication.
Not all, lordship.
National insurance is the appellant.
Yes, lordship.
Then 1 to 5.
Yes, they are the respondents.
Yes, so how have they been served? 5 has expired. Then substitute. You have implemented the legal heirs.
Yes. Legal heirs are Kush.
So how have they have been served by paper publication? What?
No. After they are substituted, lordship, then the notice will go to them. Only paper publication was for respondent number 1 to 4. That is our additional affidavit. Because when notice was sent, lordship, they did not appear for the condonation of delay. Originally, we filed a condonation of delay petition for 117 days delay in filing the appeal. Notices had gone, the respondents 1 to 4 did not appear, and 5 was dead. Then, lordship, we were asked to take steps by paper publication for issuing notice to 1 to 4. And in the meantime, since we came to know that the respondent number 5 has died, we filed those three petitions. for the condonation of delay, setting aside abatement, and substitution, Lordship. And in that also notice was sent, Lordship.
That
Because
is
this-
what I am asking. In the application for condonation of delay, the legal heirs of respondent number 5 are also necessary parties. They are to be implemented. They are implemented. What about service on them?
They are not yet implemented, Lordship. That's why these three petitions. If Lordship allows these three petitions, then only they will be implemented, Lordship. There was a delay.
Allows what? Delay condonation petition.
Yes. No. That delay, Lordship, is separate. This delay is separate.
That is what is before us at the moment. Yes.
No, this delay is for substitution, Lordship.
Number?
1061. And the original delay petition was, Lordship, 3239 of 2019. These are of 23, Lordship. Year 2023.
I am holding 1061.
Yes.
Application under section 5 of the Limitation Act for condonation of.
Yes, Lordship. That is for, Lordship, in substitution. 1061 is for delay in substitution, for substitution of the legal heirs. Lordship, these petitions are allowed, then these legal heirs will be, we have to give cause title in the original delay petition and they will be added there, Lordship. Then again, we have to take step on them.
The impression that this was the delay.
No, that original delay petition, Lordship, will find at 3239 of 2019.
Zero 61 of. Layers of the respondent number 5. The delay is as intervention. COVID pandemic. Five. Filing the substitution.
— 6162 is for setting aside abatement, Lordship. 6062.
And 873 for substitution.
873 is for substitution, Lordship, of the legal heirs.
062. IA has been abatement of the connected. Appeal connected application for condonation
Yes.
delay in preferring the in preferring been condoned. Set aside and the IS stands disposed of. This is an application. This is respondent number 5. Names are as follows. C, D, E, F,
GH.
H. Here is allowed the 5 cells then substituted by the aforesaid legal layers taken to submit corrected cause title.
Your Lordship, the
On the
delay
condonation, we should notice now.
already notice is that notice, Lordship, the newspaper. But to the legal layers, I think
Yes,
they're fresh
legal
notice
layers.
is written.
Yes.
Yes, Lordship. Condonation 3239.
Learned counsel for applicant in view of orders passed in the connected IS legal layers of the deceased 5 petitioner to take steps. Okay. It was
Post Lordship, yesterday Lordship said the
real process.
Lordship.
Will you take steps?
I think okay. Highly obliged, Lordship.
Be taken up next week.
You are supposed to file written objection.
Yes, President, I have filed objection.
Huh? You have filed. The prayer of learned counsel for the appellant, list the matter again on
Wait, please, your lordship. That 4 IAs, my lord. 3 are for substitution and 1 is for. They have filed condonation of delay. However, in case of the other 2, there is no application which has been filed. Moreover, I have gone through the office note, my lord. Even the respondent number 18 is shown to have expired. So in case, my learned senior, that substitute the layers of these deceased. All have
you
to
have
be
to
done.
file the applications.
Yes, Lordship. But one more thing has been skipped out in this entire process, my lord. The services upon 6 and 7 till date has not been taken up. My lord, I'll show the office note for a moment.
Taken up means steps not taken.
Lord, if your lordship see, dated 3/2/23, my lord, it was shown as insufficient address, and thereafter SR is awaited for all this while, my lord. You'll have to take fresh steps upon the 6. Only after the substitution is done.
Learned counsel for the appellant prays for some time to file appropriate applications for substitution of.
Regarding substitution, lordship, respondent number 11, respondent number 13 and 10, lordship, we have filed substitution petition. Regarding 18, lordship, I just want to know.
Regarding substitution in respect of the remaining deceased respondents. Prayer is allowed. Again after 2 weeks.
My lord, 18, my lord, as regards 18 is concerned, my lord, it is in the my lord, the office note, my lord, that the response has expired. But 5/1/2024.
All right, that is why we have said remaining deceased respondents.
Regarding lordship, other substitution that can be taken up lordship. Regarding respondent number lordship 11, 13 and 10.
Piecemeal it is difficult. We'll take up together on the same day. We'll pass order.
Delay is the other two are concerned. My lord, the respondent number.
In respect of certain respondents, there is delay, but there is no application
My
for
lord, all the
continuation.
3 respondents which he has filed substitution regard.
They have
Respondent
been
number
submitted.
10, there is a delay application filed. Respondent number 11 and 13, there is no delay application filed. My lord, it is from the application itself, it is seen that these 2 respondents died prior to even filing of the suit. My lord.
99.
One is in 91 and one is in 2008. So, my lord, even
But they were making party lordship in the original shoot lordship.
it was their suit, my lord, which was rejected. Their
That was
appeal which
not.
they have come on.
Whatever, they will have to file the application. Yeah, you get hold of the facts and file all the applications. Otherwise, this will not progress. Oblige.
Right, briefly, your lordship, in this case, I have kindly missed case for what happened, lordship, the earlier conducting council, lordship, he left the Gauhati, lordship, and lordship to the insurance, but by mistake, lordship, he has record, lordship. Accordingly, let the case of
That is dated, dismissal is dated 21 to 24.
yes, lordship. Accordingly, there is a delay, so I have filed a missed case, lordship.
Learned counsel for the applicant. This IA has been preferred. Seek the appeal. MSC appeal number
137, lordship. 2023.
was registered post with it post with AD. Again on.
Oblige.
In respect to item 34, my lord may kindly place order dated 14/11/24.
14?
14/11/24, lordship. That CA is lordship is still pending, not a binding, otherwise lordship, the same issue is pending before the honorable apex court, lordship.
The apex court decides 10 years later. Will all the cases remain like that?
That is not the issue. Otherwise, lordship, no one is affected here, lordship. Nobody is neither respondent is affected here, lordship. The MFA is still, lordship, to be admitted. Limitation period is
Affected means
not-
what?
Not condoned, lordship.
Not affected means what? Somebody has preferred this appeal, isn't it?
We have preferred this appeal, lordship. We have preferred this appeal along with the lordship, section 5 limitation petition, lordship. And until and unless that was condoned, lordship, the order is still exists, lordship. He can go always for execution, lordship. He can go always execution, lordship.
Then what will remain?
So Lordship, I pray for Lordship as per order dated 14/11 Lordship. When Lordship, I contacted the DSGI Lordship to SGI Lordship who has deal with the matter in the Honorable Apex Court Lordship. They have said that it will come in the Lordship first week of April Lordship.
First week of April.
Lordship, Lordship.
Let us have it after Bihu, then let us see.
Just one question which I have to make. My lord, the matter has been pending before the Honorable Apex Court since July 2020. The matter has not been taken up after that. The council, my learned senior council, has been stating this submission since past 2 years, and since this matter was last registered in 2024. It was never come. My lords, may I kindly place reliance on the Supreme Court judgment which says we are seeing before us judgment and orders by the High Court, not deciding cases on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating thereto is pending. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not open for the High Court to refuse to follow a judgment by stating that it has been doubted by a later coordinate bench. In any case, when a faced conflicting judgments of benches of equal strength of this court, it is the earlier one which is to be followed on by the High Court. My lord,
Yes, that is the position.
The dictum is Lordship, there is no disputed Lordship. Dictum is nobody disputed the dictum of the Honorable Court Lordship. We are not disputed Lordship.
Sir, please let me speak.
Otherwise Lordship, the matter is.
My lord, the matter has not been taken up in the Supreme Court since past 6 years. How long should I be waiting, my lord? And my lord, it's not like anything survives in the matter. Decree has been fulfilled. Everything has been covered, my lord. We have just been appearing.
There is no any stay order Lordship. He can go for execution at any moment Lordship.
What was the decree?
Decree, my lord, the decree was of 11,23,497 and we have received that decretal amount. Lords, I don't know, nothing survives in the matter.
Been satisfied by way of any execution proceeding or of their own?
Execution application in the execution proceeding itself, they have paid. The railway has paid.
So what remains of your appeal now?
Lordship, it will be outcome of the Lordship. Yes, because the observation is there in the execution, later execution, there is observation Lordship. Later execution in the other cases, there is observation.
Has only power to execute the decree. And the decree, nothing stays beyond that. And if they had anything, then they shouldn't have paid. They have paid. They have fulfilled.
The matter in the first week of April, Lordship. We'll
not the doctrine of approbate is applicable. They cannot refuse it now.
Right, then on the next day, we'll hear on the that this is maintainable, the application is maintainable or not. If in the meantime something comes well and good, otherwise we'll decide.
Allowed a date.
Yes, of course. Agreed to by learned counsel for the matter again on 3rd week of April. Okay.
See, item 37 also similar.
Allowed, may please have it be a bit early. Of March.
It will come on first April or so.
They're saying it's coming in April.
My lord, may I have it on?
There are 37 to similar. 37. 37 also losses similar.
Much obliged.
Please, Your Lordship. Your Lordship, in this case, respondent number 1, 2, 3, 5 and 6 have already entered appearance. But in respect of respondent number 4, no service received, Your Lordship. Lordship, in this case, we have taken steps only through usual process, Your Lordship. So, Your Lordship, I pray that we may be allowed to take steps upon respondent number 4 through speed post, Your Lordship.
This accident took place on 28/3/2023. That is 3 years already been passed. My prayer is interim compensation. Interim order is required to in regard to 50% of the awarded compensation losses. Because he was the sole earning member and the dependents were 5. Wife, 2 children and old father and mother.
Lordship, that IA has been disposed.
He has been disposed of saying what?
In disposal of the appeal, Your Lordship. I has been disposed. Your Lordship may peruse IA civil number 3819 of 2025, Your Lordship, dated 28/11/2025.
What was that IA for?
That was for stay, Your Lordship.
Then the different matter. You file separate application.
We have not received IA notice
That
of
can
IA.
be disposed of.
Earlier it was disposed of.
So who is the respondent to be served now?
Respondent number 4, Your Lordship. He's
For
the
the
owner.
owner of the vehicle.
He's an accessory party, Your Lordship.
Earlier you took steps
Yes, Your
by
Lordship, through usual process, Your Lordship.
usual process.
Lordship.
No report.
Service report has been received.
Learned counsel for the appellant. Also for the respondents 1, 2, 3, 5 and 6. And to take steps by speed post. AD. Earlier also there was an order and is directed to praise the postal track consignment report of the notice to respondent number 4 by speed post.
That could not be done since we had taken steps only through report states like that, Your Lordship.
But this time you take by speed post then.
Lordship.
To file application. Done on the previous. Again
on that may be fixed, Lordship. After
Yes.
1 month on that may be fixed, Lordship.
6.
Respondent number 1 to 6 here. 7 and 8 government service company. NCRs were called by office note dated 17/12, Lordship. Here there is no office note, Lordship.
All the respondents have appeared.
Yes, Lordship. Service complete.
At learned counsel for the appellant. Learned counsel appears for respondent number
1 to 6, ma'am.
1 to 6. 7 and 8. 7 and 8 also appears. Total 8 respondents. However, TCR has called for has not been received. Registry to issue reminder. Is the matter again on?
Obliged, Lordship.
Your Lordship, I'm sorry, my lord, extremely. My lord, I could not appear, my lord. On the other hand, I could not prepare the case. Lordship, kindly take up the matter on Monday. Well, I was preoccupied with other cases. Matter relates to my review, and there is a delay of about 59 days. And in the review, there are some, my lord, question to be, my lord, raised support of her case.
This I is for what? Delay.
Continuation.
Prayer of learned counsel for the is the matter on
Tuesday. Bless.
Me, Lordship. The Lordship may peruse office note dated 2/3/2026. Lordship, AD card and service to your report has not been received in respect of respondent number 1 and notices were issued on 24/1/2026. Your Lordship, service report may be awaited, Your Lordship.
office note dated 25 to 1 and 4. Mode as well as by speed post. In respect of the said respondents are who is 2 and 3?
Number 2 and 3, they are the minors, Your Lordship, respondent number, and they are represented by respondent number 1.
2 and 3 are represented as they are minors. Private service. Begin.
Obliged.
May it please your lordship. As per the office note dated 2nd March 2026, the service report in respect of respondent number 4 and 5 is still awaited. In the meantime, I may kindly be permitted to serve respondent number 1 and 2 by way of dusty service, your lordship.
As per office note dated 2/3/20. So AD cards in respect of respondents number 7 have been received back. Further, no ID card or unserved notice. 4 and 5. Then to take steps by dusty service upon respondents number 5, 6, and 7.
4 and 5, Your Lordship.
5. Then you have to take fresh steps otherwise on 6 and 7 because it's not. Where are these people? 6 and 7 addresses where?
To obtain instruction.
So all are residents of Dibrugarh. So if you take dusty service on 4 and 5, we can take on the others also. 4, 5, 6, and 7 dusty. What about others? 1, 2, 3, 4. All those. The other respondents.
In respect of respondent number 3, I may need to obtain instructions, Your Lordship.
Here any steps have been taken? Council to obtain instructions regarding the service upon remaining respondents. The matter again on.
Obliged, Your Lordship.
Please, Lordship. Just kindly Pharaoh's office note dated 2/3/2026, Lordship. There's a notice upon respondent number 1 answer with remarks, Lordship, addressee left. And respondent number 2 has expired, Lordship. And respondent number 3 refused to accept the notice, Lordship. And respondent number 4, Lordship, addressee out of station for long time. And upon respondent number 5, 6, and 7, notice has been served, Lordship.
As per office note dated 2/3/26. लिखी दिवा यहाँ पे ऐसे है. Above it appears that service in respect of respondents 10, 7, 8, and that on respondent number 3 may be taken to be 8. To 5. Amendment note. Close. 126. In proper address of the take steps by speed. Again on.
Also, interim order may be continued.
Interim order passed earlier to continue.
Lordship, while issuing notice, we are given liberty to serve Dusty, Lordship. We have served Dusty. Office notice there, Lordship. Dated 2nd of March, Lordship. We served the Dusty notice on 24th February, and we have filed the affidavit on 27, Lordship. The service is complete, Lordship. Kindly consider my
Only one respondent is there.
sole respondent. He is the plaintiff.
Third learned counsel for the.
Lordship, may kindly consider my interim prayer today, Lordship. Prima facie, there is perversity in the order, Lordship. Earlier it was a case of specific performance, Lordship, and after the proposed amendment, it has been diluted and given a structure of recovery of khas possession and right title and interest, Lordship. And on one occasion, the plaintiff filed a petition for amendment that was subsequently withdrawn, Lordship. And on the same ground, subsequently he has filed a petition under Order 6 Rule 17, Lordship, which was allowed, Lordship. And entire nature and character of the suit has been diluted, Lordship. It has been changed, Lordship. And that has been filed, the proposed amendment petition has been filed after filing of WS from our side, Lordship. WS and counterclaim, Lordship. And now he is denying his own admission in the plain Lordship.
For the defendant.
I'm the defendant. Sir. We have submitted our WS along with the counterclaim, Lordship. And thereafter, they came up with an amendment petition which was withdrawn, and subsequently again another amendment petition with the same ground, Lordship. Prima facie, we have a case, Lordship.
Mr. Didas.
Didas, Lordship.
by the court as well as stated in 226. The petitioner had taken steps by and also by usual process by way of dusty service. And affidavit in this regard has also been learned counsel on the prayer for stay of the impugned order. Submitted that the petition of the plaintiff respondent under Order 6, Rule 6 in CPC. In the proposed amendment and character of the suit changed, and that too after filing of you filed written statement.
Yes, Lord, along with
Filing of the
counterclaim.
written to the fact that despite service of notice, order dated so and so silo into order dated unto self remain paid till the next date of listing. Record is to be called for.
Yes, Lord.
Same call for the and copy of the TC. The matter again on
Order proceeding may also be stayed also.
order.
Service of respondent number 2.
Therefore,
One Lordship.
so we have to await.
Yes.
Learned counsel for the applicant and number 1. Yes, from postal assignment report that service is not yet complete on respondent number. Hence await service on respondent. May I please? Matter the respondent 5 and 6 have filed their wakalatnama and responded. How many respondents? 7 respondents.
So you are for?
One.
Only one. Yes, what have you got to show that you have taken steps?
Yes, your lord. First step was taken on 27th 1 2026, but it was in defect, your lordship.
So till now, nothing has been done.
Fresh step has been taken, your lordship.
When?
On after last date of listing, your lordship.
No. 27 to 26.
9
After that?
After that, your lordship. 27-2, we have taken the fresh step, your lordship, as it was in defect, your lordship. Robert, the 4, 5, 6 and already entered their appearance, your lordship, as per cause list, your lordship. And 3 remaining, your lordship.
Where is it?
As per cause list in IA, your lordship. 4, 5, 6 are, yeah, man.
Appears for respondent. Cause list. Entered on B 5 and 6. It is submitted that pursuant to last order dated 27 to 26. Steps have been taken. The applicant, the remaining respondents. But there is no office note. There is no office note in this regard. Registry to verify and the matter again on
20. 23. Around 30.
Yes, obliged, sir.
Your lordship, in IA, the interim may be continued.
A.
Obliged.
Yes.
Steps has been taken.
When?
24.
Counsel for the applicant submits that steps have been taken of the respondents on 6. By list again on.
My lord, we had filed a partial modification of the order, my lord, dated 5/1/2026. My lord,
My
initially,
lord, copy may be served, my lord. I received the copy.
copy was served. The office.
That is also not
Nothing is mentioned here.
Had it been served, my lord, one notice should be there. That has not been served upon me, my lord.
IA has not been served upon. Course of the day.
Copy right now, my lord.
No.
Yes, sir. We'll
The
serve a
course of
copy.
the day.
Today we'll serve a copy, my lord. Let it be fixed on 9th, my lord. Because this is only an application to have a child visit, my lord. Because the High Court, Honorable High Court has stayed the order. Because of that, I am not able to child, my lord.
In the trial court, that has been stayed by this honorable court.
But child visitation cannot be stayed, my lord.
I have to peruse the copy, my lord.
Lordship may see the IA, my lord, last IA page for 30, my lord. In view of this order, my lord. Further considering the submission made by the learned counsel for the petitioner, let the further proceedings be stayed till the next date of listing.
What exactly is the proceeding?
It's the
Guardianship?
guardianship, my lord.
It is
Under
a-
section, we have filed it. Because
of the minor son, my lord. That suit was dismissed for default. And they came for revision of that order before the trial court after 6 months or something like that.
and the trial court has restored the petition, the guardianship act case, my lord.
When did you last see your child?
Last matter, I think,
Prior to December.
December, my lord.
December.
And now I'm not allowed, my lord, in view of page 18 order, my lord.
All right, Friday.
Friday. Right. Yes, obliged.
Right, please, your lordship. My lord, will peruse the office name dated 23/2/2026, my lord. Steps were taken against respondent number 425. Sorry. 125, my lord.
I'm appearing for 125.
Or 125.
And LCR was also called, my lord. That has not received.
Internet counsel for the.
I'm appearing for respondent 6. Some DC.
Number 1 to 5 are represented by.
Paul Oscar.
Bhattacharya, respond.
State respondent number 6. Here is call has been. TCR has called for. Is yet to be received. Letter again on.
My lord, there is another. There is an IA there, my lord.
IA for?
IA for stay was there, my lord. I was directed to take steps upon respondent number 1 to 5. I will give them a copy, my lord, that we could not serve them a copy of IA. That, my lord, I will do it. And we were also given a liberty to make Union of India as a party if we feel necessary. My lord, that
we will require some time, my lord, because some office approvals and other things are there. We being government organizations and approvals. So 2 weeks time, maybe, my lord, we
Response number 6.
it has already been done. Response number 6 copies were already been given, my lord. And that is the reason the last time the matter response number 6 appeared. But if my senior requires, I'll give them a copy. No problem there, my lord. Let it come
Yes,
after
we
due
did-
vacation, my lord. That is
When
what
do you
I'm
want?
praying.
When do you want?
After due vacation, my lord, let it come.
Date.
22nd of April. Bye.
None appears for the appellant. AD card in respect of respondent number 1 has not been received back. LCR has been received. Have its service on. Number 1 list again on. Listed for hearing.
Yes, your lordship, it has been.
It is longly listed for orders as it is ready for hearing as reflected in the order dated 12/9. The matter for hearing on.
Right.
Item number 6 was
I get 2.
My lord, item number 48, my lord, the hearing matter, my lord. The counsel, Mr. A.K. Purkar, support argue the case, my lord. Maybe fixed on 13th, my lord. I'm appearing on behalf of 13th of March, my lord, Thursday.
What is the item number?
48. Friday, Nikki? Thursday.
Not on a Friday.
19 of March. Tuesday. भालो हो गया
item number 6 was the name of my senior was not showing. That's why we were not able to.
Who is PDAS?
An old junior of time of filing the case. The name
Item number 6. What is your senior's name?
JC Gaur.
Is the matter? Showing the name of sir. GC.
Applause, my lord.
May I please? Ready for hearing, so kindly fix a date for hearing. Here has been received. Sole respondent.
Sole respondent. The order is there. I don't know why they keep coming for orders. This is longly listed for orders. Listed for hearing on.
And it have on 12th of May. Stabilize.
You receive office note dated 5/3. So for respondent number 1 is concerned,
yes,
I will take fresh steps for number 1. And so far 2 is concerned, it may be awaited. It was sent, your lordship, on 30th September 24. I will take fresh steps of both of them.
Counsel for the appellant submits that fresh steps will be taken on both respondents number 1 and 2. Is allowed. Is taken on.
For LCR, reminder may be issued, lordship.
So issue a reminder for this year.
Please, your lordships. My lord, the main RSA, my lord, was dismissed for default, my lord. For this miscase for restoration, my lord. I have already complied with the order of this honorable court. Paid the cost of rupees 5,000, my lord. I have stated in my para, my lord, para 3, 4, and 5, my lord. I have stated the reasons, my lord.
Learned counsel for the applicant. Decision. Your deposited cost.
Yes, my lord. IA 1643, my lord, public 25.
Essay number 80. Regard to the causes shown. Trying to. File. Accordingly. Appeal. What is that? What stage it was dismissed?
Admission stage, my lord.
Admission.
My lord, execution basis, my lord, around 16 of this month, my lord. Possible, my lord, on 12 or 13, my lord, for admission, my lord. Otherwise, my lord, that case is pending. 12 or 13, my lord, as per convenience of this court, my lord. This month, my lord. On 16, Oh, yes, I'm sorry, my lord. Obliged, my lord, much obliged.
We must have. Okay.
Yes. I will serve the copy, my lord. Today itself, my lord, I will serve. Obliged, my lord.
My lord, service is complete upon respondent number 1, 2, and 3, my lord. 4 is not necessary party, my lord, because we have filed appeal on the ground of only quantum, my lord. That's fine, lord. Maybe struck off, my lord, and TCR may call for, my lord.
Alternate counsel appearing.
Yes, my lord.
Please, my lord. Here, Lordship, today one stay application has been listed, Lordship. In earlier occasion, Lordship, in the appeal, Lordship, a notice has already been issued. But the stay application was not on record on that day, Lordship. So today it has been listed. Lordship, we are ready to deposit the 50%, subject to stay of this award, Lordship. On last occasion, notice was issued in the appeal, and TCR called for. I've already taken steps, Lordship.
So we are on the IA today.
We are on the IA regarding the stay application, Lordship. We have filed actually later on. And here, Lordship, 50-50 award was given. So we are liable for 50% of the award. So we are depositing 50% of the 50%.
IA 2/5 of 25 had learned count. Yep. And insurance company, which one?
Yes, we are National Insurance Company.
National Insurance.
Present appellant.
It has been preferred stay of the judgment and award in 11/24. Regarding case number 42 of 30, a sum of rupees 32,6,4 of 50 with 9% interest per the date of filing of the appellant to deposit percent of it word. Which share of the award, which comes to how much?
If I have to calculate, they will calculate, so they will deposit, Lordship. We'll deposit within 4 weeks, Lordship.
Paid. Highest and again highly appraised. You have to take fresh steps. Huh? Address has changed. Hearing for the applicant is for time to take regarding change of address. Again, after 4 weeks.
And for
This has been preferred by the
payments.
payment and your
For the insurance company.
of MSC appeal number 146. Years for the in the please hang on, give a 4 weeks.
My lord.
Please, Your Lordship. This matter, my lord, we have filed an IA. Of the IA, my lord. Case number 16. The appeal was preferred by the insurance company, my lord. It was admitted. And also, my lord, the judgment was stayed. Subject to deposition of, my lord, 50% in the registry, my lord. So this IA, my lord, we have preferred, my lord, for allowing us to, my lord, receive this money, my lord.
The applicant and the IA has been preferred to withdraw 50% of the awarded compensation by the insurance company, the registry. Prayer is allowed. The deposited amount stands disposed of.
Adding service and record.
Records can come. Connected appeal, you read, ready for hearing, is the same thing on.
Highly appraised.
Lordship, I is for withdrawal. The petitioner approached this honorable court challenging the order of the executing court. But this honorable court had issued notice in the CRP case
but no interim has been given. Restraining respondent number 1. Absence of the interim order, the petitioner will
Third learned counsel for the applicant. This I has been preferred, seeking if to withdraw the connected CRP within bracket I stroke O for 51 of 26. There is allowed the CRP 1 I stroke O. I extends this of tense dismissed on withdrawal.
oblige.
In this case, sole respondent. Otherwise, I'm ready to argue the matter, but not on the respondent side.
Learned counsel for the appellant is present. However, learned none appears for the is the matter again on the name of who was appearing. Union of you are for Union of India.
Lordship, NFLA. I may bring Union of India, represented by NFLA.
Knowing the name of learned counsel for the respondent. On given date.
11th of April. I'm deeply obliged.
Testamentary appeal arising out of dismissal of the testamentary suit. Will was declared genuine, but it held that it was application was filed after 3 years of demise of the testator. On that ground, it is dismissed. The respondent on appearance filed a cross objection also.
So factually, what is the position? Was it filed after 3 years or?
It is the beneficiary was minor. He attained minor immediately after his attaining of majority, it was filed. From the demise of the testator, it is after 3 years. But Section 223 of Indian Succession Act says that no probate can be granted to a minor or answered minor. So it could not have been granted if it even if it is filed before his attaining of majority. So this is my ground on limitation that Section 23 bars. So it could not have been filed. And in the petition also, it has been mentioned that.
What about any guardian of the minor?
The mother was appointed executor of the will. So mother filed it after his attaining majority. And another ground was that paragraph 7 of this petition, it is mentioned that
if the mother was the executor, at the minority of the beneficiary, filed within the period of limitation, was it not?
My humble submission would be, Lordship, the probate is to be granted to the beneficiary, not to the executor, for the benefit of the beneficiary.
Let's see the section.
Section 223 of Indian Succession Act.
Twenty-three.
223. Persons to whom probate cannot be granted.
It need not be granted to the beneficiary. It is to be granted to the executor of the will.
In that case, guardian should be legal guardian appointed by the court. In the will, mother was appointed executor.
The natural guardian, when natural guardian is there, why should court appoint another legal guardian?
But for grant of probate to a minor,
there is no question of granting probate to a minor. Probate will not be granted to the beneficiary. It will be granted to the executor.
Even if it is for the benefit of the minor lordship.
Doesn't say benefit of.
It says probate cannot be granted to any person who is minor.
Granted to the minor. It will be granted to the executor only. 224.
Yes, it is there in 222. When several executors are there. Appointed probate may be granted to them all simultaneously at different times.
222. Can be more clear than that. Where is the judgment?
Page 23. Discussion.
Where is the point of limitation discussed?
Number page 48. This
is the point of limitation. Issues? Page 27. No issue framed.
Probate. Specific issue limitation was not.
It was discussed within the issue of maintainability.
Yes. And that the minority of Abhijit Goswami is barred for grant of probate. It is their issue number 5.
This issue has been decided, just what I have said.
Another point what has been observed, that it was not accompanied with any application for condoning delay. Now, regarding this lordship, this Shashnath Singh case, recently Supreme Court, that it is not always required. If it is explained, the petition, it can be also considered.
Where is your petition?
My petition is page 10.
So where have you explained?
Lordship, paragraph 6 and 7. Please read page 13. By the aforesaid will, the petitioner, that is the mother of the aforesaid, Sri Abhijit Goswami, was appointed executor of the aforesaid will till the minority of said Abhijit Goswami. And after the majority, Sri Abhijit Goswami, his mother is a petitioner, and Sri Abhijit Goswami were by this said will appointed executors jointly and severally, and to apply for grant of probate after the death of aforesaid Surendra Gosai. That as because aforesaid Sri Abhijit Goswami was minor, at the point of time be made specific mention in the will that the original will be kept in the custody of his other brother, Sri Rohit Gosai, son of late Shiv Toran Gosai of Itkola Silchar town, till Abhijit Goswami attains majority. Sri Abhijit Goswami attained majority on 24/2/2015, and thereafter aforesaid Sri Rohit Gosai handed over the said original will to the petitioner in due compliance of the last wishes of the testator. My humble submission is these explains why it was not filed.
So you have yourself decided that this is the law, I'll have to apply only after I attain majority. Yes.
No. This is the explanation for delay. That is, I do not have any other explanation. This is the explanation. 23.
Para 6 and 7.
Yes, para 6 and 7. And if Sheshnath Singh can be applies to our case.
Give the citation.
I will decision also. Paragraph 63. Paragraph 63 and paragraph 64.
Sixty?
63. Page 13. Paragraph 63.
Result? Yes.
First, I'm running argument. After cross objection is there. Try to cross objection questions. So far, this is concerned with the judge. Judgment of the Supreme Court. Activity Bhagat. It is what is the name of? Part of my duty and because accrued on the death of death. Our High Court judgment is there 2018 3 LT 190. But paragraph 9, 10 and 12.
This is on the point of limitation, that 3-year limitation applies.
Yes, madam. I'm just presently I'm on that matter. Now, ten and 14, madam.
Yes.
Now, my lord, paragraph 6, if your lordship will see again, my lord. So, my lord, by the aforesaid will the petitioner that the mother of the Abhijit Goswami, the majority of the Abhijit, after majority of the Abhijit Goswami, his mother and the petitioner, the Abhijit Goswami were. So, till a minority, my lord, the mother can apply. Mother can clearly apply.
Yes.
So that is why I submit, my lord, that the finding is absolute. Now my cross objection, my lord. For cross objection, issue number 2 and 3, my lord. That is that your lordship will find at page 46 of the judgment.
Page
46.
running page.
Page 24. Interior page of judgment 24, running page 46. Got it, my lord? Paragraph 10.
Yes.
Let us discuss issue number 2 and 3 respectively, whether will is false, fabricated, manufactured, tested, or will was there without any influence from any corner. It states that in August 2008, Sudan Gosai got prepared a will in respect of 8 kathas of land in Meherpur, bequeathed such land in favor of Abhijit Goswami. Such will was prepared by Sri Tamal Singh, advocate, clerk, Catholic extraction. Thereafter, he executed the will in presence of himself, his brother Rohit Gosai, in good health and mind. He states that Surendra Gosai understood the disposition of his disposition such properties in favor of Abhijit presence of himself, Rohit Gosai and Subhash Chandra Kaur. At the time of execution of will, the aforesaid Gosai was in good health, mind, and he made the disposition of such properties as mentioned. There was no undue influence for coercion. The evidence of two witnesses, there is nothing to disbelieve. They are only finding, my lord. I shall place the evidence on that, my lord. But we filed objection, my lord. And if your lordship will take up the evidence, my lord, in this regard.
Evidence filed. Yes.
My lord, if your lordship comes to cross-examination of PW1, my lord, Savitri Gosai, the mother,
Also PW1. Yes.
Line about 7, my lord, your loss is fine. Surendra Gosai had many cases. I had many cases
Yes, pending in the
sister
Silchar
court
court.
against the tenants and his brothers, and my husband is the party of the suit. So suit is filed against the husband also, my lord, the Abhijit Gosai's father. Surendra Gosai, then it is not a fact that my husband conducted some suits on behalf of Surendra Gosai. After the death of Shiv Baran Gosai, 7 sons are entitled to 1/7 share of the property. In fact, Surendra Gosai suffered from stroke in the year 2005, my lord. Very important, my lord. He was in the bed. It's not a fact that he suffered from the stroke, rarely attended the court. It's not a fact that suffering the stroke, or he died on so and so. Abhijit Goswami is my son. He is now aged about 22. The year 2008, my son was minor. At the time execution of the will, my son Abhijit Goswami was minor. I cannot read and contents of the so and so. At the time of execution of Exhibit 1, I was not present, my lord. So, mother was not present, my lord. So, at time of execution. Then, my lord, your losses may come further. My husband, a grade for employee of Central School on temporary basis. No punishment was awarded against my husband in the year 1989 in a criminal case. It's not a fact that after the conviction, he was terminated from service for Central School, so and so by executing the will, bequeathed the headquarters for that. Now, my lord, your losses may come further, my lord. Next, my lord, the cross examination on 10th of October.
Yes.
Surendra Gosai had brain stroke, so and so he recovered later. I did not submit any medical documents showing recovery of the Surendra Gosai on stroke. There was a lot of litigation on Surendra Gosai in Silchar court. It's not the fact that my husband used to look after the cases of Surendra Gosai. The land pertaining to the will in respect of so and so, number so and so, Moja, pertaining to Moja Ambikapur. Not the fact that Ambikapur part 2, that is, there is no mention like second arrest pattern number 12. I do not know whether there was any suit filed by Promila and others by title suit number so and so in the court of Appeal Chapter 2. I do not know whether one title suit was compromised on 10/3/11 because before the court of civil judge number 2. I do not know whether other lands of Surendra Gosai related to second arrest pattern was involved in title suit. The alleged will was executed on 12/8/2008. By the will, Surendra Gosai bequeathed the land to my son Abhijit Goswami. At the time of execution of the will, the executor he executed the beneficiary was minor. I cannot read what is written in Exhibit 1. The will is written in Bengali, but it was read over to me. He was not present, but he says now read over to me. Tamal Singh read over the contents of Exhibit 1. I do not remember exact date when it was read over to me, and it was written in 2008. As the beneficiary was minor at the time of execution of the will on behalf of the minor beneficiary Rohit Goswami accepted the bequest, that bequest. It is not written in Exhibit 1. This is also the person, Rohit Gosai is also, the cases were filed against him also. I shall come later. I do not know if Rohit Gosai filed a case against my husband. I do not know whether title suit number so and so Rohit Gosai and my husband is still pending before the court. I have not gone through the objection filed by defendant object in the case. I also did not inquire about the objection filed by the defendant's objector from my engaged lawyer. Not the fact that executed will is a forged document. Not the fact that I, along with my husband, created the will for illegal gain. It's not the fact that land mentioned in the will is practically not in existence in the locality. It's not the fact that I am not able to get the profit to the will. Not the fact that. Now, my lord, your losses may come to PW2, my lord. What's on the 4? Because here two witnesses were shown, first on the 4 and that's Gosai, my lord, one brother, as a attesting witness. But the other witness was not there, my lord, at all. At that time.
PW1.
PW2, no, that was not examined, my lord. Was not examined also. Now, Subhash Chandra Kaur, if you also will see, my lord. The losses, man. Must see that cross examination of the PW2, my lord.
Which one?
PW2.
Yes. Chief or cross?
Cross. I am residing at Vidyasagar Soroni since 15 years, and before that I was a resident of Silpar, Silchar. Presently I am residing in a rented house at Vidyasagar Soroni. I used to know Surendra Gosai since last 30-40 years. I went to Surendra Gosai for purchasing a land at Meherpur, and in that acquaintance I came to know Surendra Gosai. I do not know whether Surendra Gosai had a brain stroke and he was attacked with paralysis. I cannot say when he died. I met Surendra Gosai lastly in the month of April 2009. I do not know his sons and daughters and how many members their family. Exhibit 1 will was written in the house of Surendra Gosai at Chitakola. Well, this is very important. Your losses may just note down. Written in the house of Surendra Gosai at Chitakola. Here is contradiction. One Manipuri person wrote Exhibit 1 will. I cannot say the name. The writer, after writing the said Exhibit 1, read over the same. And at the time, Surendra Gosai, myself, and the said writer was only present. My lord, your losses can note down. Only 3 persons were present, my lord. That other Gosai, the attesting witness, was not there at all, my lord. Exhibit 1 is a
What are the names of the attesting witnesses relied upon by the court?
My lord, 2 attesting witnesses were there. One is, my lord, Rohit Gosai, and other is Subhash Chandra Kaur. But Rohit Gosai was not examined. Litigations are there with Rohit Gosai against the father of the minor, my lord. Husband of Pilwan. Now, Exhibit 1 was written on a stamp paper. In Exhibit 1, I put my, now it is a written on a stamp paper. My lord may see whether it is on a stamp paper. In Exhibit 1, I put my signature as witness, and thereafter I left the house of Surendra Gosai. After writing of the will by the scribe, the said Surendra Gosai instructed me to sign the will as a witness. And thereafter Surendra Gosai signed. My lord, this is also long, my lord. Firstly, first testator is to sign, and thereafter attesting witness to sign. And at the time, no other persons were present. Not a fact that no will was executed as Surendra Gosai. It is a fact that statement made in my examination chief are false. I submitted my examination chief, so and so. Now, the writer of the will is examined also. This is the losses may see the cross. Our allegation was that father was looking after some cases, my lord, because he suffered a stroke and he was in paralysis, and he to take signature on the papers, my lord, for the purpose of Hajira with very other things, my lord. And those papers were used in the will. And if you also see that will also, it proves it. Now, your losses may see the cross examination of P2 my lord.
Yes.
I worked with Advocate S. Chaudhary. Prior to that, I was also worked with the father, his father, late Piyush Chaudhary. I worked under him for more than 30 years, but I cannot remember, cannot say on whose date I joined the chamber and worked up to whose date. I cannot remember the date of Advocate Piyush Chaudhary. I knew Surendra Gosai, now he dead. I cannot say when he died. It's a fact that Surendra Gosai suffered a brain stroke in 2005, and due to stroke, he had also a paralysis. My lawyer, let Piyush Chaudhary, with whom I work, got many civil suit of Surendra Gosai. Surendra Gosai had 5-6 brothers. Plaintiff husband, Ashok Gosai, is also a brother of Surendra Gosai, and his father was late Shiv Baran Gosai. Surendra Gosai also filed many suits against his brothers, including Ashok Gosai, out of whom one PS 7086 in the court of civil judge so. Ashok Gosai is also known as Gopal Gosai. Exhibit 1 is written by me, and the same was exhibited after stroke of Surendra Gosai. The draft of Exhibit 1 was written by me 2-3 days, my lord. This is very important, my lord. Prior to execution of Exhibit 1, earlier green paper, which is known as 13-inch paper, is used in the court work for filing petition Hajira. When the case of Surendra Gosai was there in the first of my earlier lawyer, Piyush Chaudhary, Hajira petition was given by Surendra Gosai in the said green paper. Surendra Gosai had vast landed properties in Kachar district. There are other suits and proceedings of Surendra Gosai regarding the property. He used to sign 13-inch green paper for using the same as Hajira for petition in the suits and other proceeding, my lord. I neither filed the draft of Exhibit 1 in the court, nor I brought the same with me today. Exhibit 1 was executed in the house of Surendra Gosai. Before execution of Exhibit 1, Surendra Gosai has gone through it. Well, this is again another contradiction. They say that they read over to him, but he said it's gone through it. The execution was done on 12/8/2008. At the time of execution of Exhibit 1, Surendra Gosai, another brother, namely Rohit Gosai and Subhash Chandra, were present. My lord, now your lawsuit sees the contradiction. Exhibit 2 said that only 3 persons were present. And he said that Rohit Gosai was present, my lord. Rohit Gosai. Prior to 12/8/2008, I did not know Subhash Chandra. I do not know whom he resides. It is not a fact that Surendra Gosai has no sound mind and health. I was lying in bed, almost unconscious. He was under medical treatment. At the time of execution, no doctor was present. It's a fact that Surendra Gosai did not execute Exhibit 1. It's not a fact that brain stroke Surendra Gosai imbalanced physically. I have no paper to show that Surendra Gosai was hale and healthy on so and so. Not a fact that Exhibit 1 was manufactured with the help of husband of the plaintiff, Ashok Kumar Gosai, and myself on a previously signed paper of Surendra Gosai. When the petitions are filed in the court, verified petitions also required to be filed in the said petitions, and signature of the petitioner are obtained in the front portion and bottom after verification. Not a fact that concocted and cohesive, not so and so. My lord, if your lordship see the will, my lord, then it will appear. Now your lordship seen the 3 witnesses, how many my lord, contradictions are there. Now I shall rely on 2 judgments of the Supreme Court, my lord. Latest judgments. My lord, one is my lord 25 2 SCC 633. Paragraph 5 onwards, my lord, I shall place, my lord. Paragraph 5 at 636.
Yes.
After framing the issue, the learned single judge found that the will in question was duly executed at the same time. It was further found that the will was shrouded with suspicious circumstances, and the plaintiff could not satisfy the conscience of the court by removing such suspicious circumstances. Resultantly, the suit was dismissed. In appeal, the division bench did not formulate the points for consideration. At the same time, on reappreciation of evidence, found that learned single judge has correctly come to a conclusion that will in question was validly executed. The division bench held that learned single judge has recorded a finding that will is validly executed and is genuine, and observed that held that suspicious circumstances, if any, have been taken into consideration by the court before recording finding that the will is genuine, and not after recording a finding that the will is. In that view of the matter, the findings recorded by learned single judge that the will is shrouded with suspicious circumstances set aside, and consequently held that the plaintiff is entitled to grant LOA. Accordingly, testamentary suit is decreed. In the contextual situation, firstly, it is to be found out whether the learned single judge has arrived at a finding that will is genuine. No doubt, the exposition of law by the division bench that such circumstances, if any, has to be taken into consideration before recording the finding that the will is genuine or not, and not. After recording the finding that the will is genuine is correct enunciation of law. Then the question is whether the learned single judge in the testament dispute has arrived at a finding that the will is genuine. In this context, we cannot lose the sight of the fact that holding a will is validly executed and a will is genuine cannot be said to be same. A will is found to be valid, not validly executed. In other words, invalid owing to the failure to follow the prescribed procedures. Then there would no need to look into the question whether it is shrouded with substance or not. Therefore, it can be said that even after the propounder is able to establish that the will was executed in accordance with law, then the will only leads to the presumption that that is validly executed by that by itself, if no reason to converge the position, that would amount to finding with respect to the genuineness of the same. In other words, even after holding the will genuine, within the jurisdiction of the court to hold that is not worthy to act upon being shrouded with suspicious circumstances when the propounder failed to remove such circumstances to the section of the court. Now, 12, para 12. A scanning of the judgment of the learned single judge after holding the will so and so is validly executed on the following three grounds taken as suspicious circumstances surrounded by the will in question. The learned single judge declined to grant LOA, holding to the plaintiff has failed to explain the suspicious circumstances surrounding the execution of the will. The clause failed to explain suspicious circumstances surrounding the execution of the will. If taken only a finding that it was validly executed, but till it is surrounded with suspicious circumstances, then only it can be said that the learned single judge was justified or correct in proceeding with the matter. At the same time, if it was taken that the learned single judge had only recorded that the plaintiff has succeeded in proving the execution in terms of provision of section 63 of the Succession Act and section 68 of the Evidence Act in the light of a well-nigh settled position of law, it will be open to the court to consider whether it is to duty of the court in case of objector raised suspicious circumstances to call upon the propounder to remove such suspicious circumstances to satisfy the conscience. The proposition is well settled. So and so. In city so and so, for proper consideration of the case in hand, it opposite to refer to the decision of the court in Montana versus so and so, rendered after referring to and relying on the various previous authorities on the legal requirement to prove a will. This court had elaborately considered the essential legal requirement to prove a will and ultimately held that mere registration of a will would not reach it to a stamp of validity. It must be proved in terms of legal mandates under the said provision of section 63 of the Succession Act and 68 of the Evidence Act. Now, my lord, your lordship may come through paragraph 22.
Yes.
The question in the aforesaid circumstances is that in absence of definite finding regarding genuineness of will by the learned single judge in the testament suit, whether division bench was justified in holding that the learned single judge has made a specific finding regarding genuineness of a will without considering the question whether the cumulative effect of the finding returned by the learned single judge would be taken as a finding on the genuineness of the question in the affirmative, and thereby making a further probe into as to whether the will in question is surrounded by suspicious circumstances beyond further consideration. In that view of the matter, the impugned judgment is set aside and the matter is remanded to fresh consideration by the division bench in accordance with law. We make it clear that we do not make any association. The suspicious circumstances are very much there, my lord. Here I have read, and now I shall place another judgment of Supreme Court, my lord, is 2022, page 238. Here on I said placed only 3 paragraphs.
Yes.
Paragraph 9, my lord. Opinion of the High Court that will was probed in terms of section 63 of section 1 while coming to a finding that High Court was deep into factual inquiry. It is evident from the judgment and the appeal that formulates the question of law on the question of fact only. Moreover, in the formulation of the question of on the basis of which the appeal was admitted, High Court proceeded on the basis that the will was probed in terms of section 63. The person claiming to be the scribe of the will as well as the two attesting witnesses deposed to support the case of the original plaintiff, but both the trial court and the first appellate court disbelieved their testimony. Some impression of Kishan Singh was not matched. There was contradiction in the evidence of attesting witness as regards place of execution. The requirement of section 63 of the Succession Act 1925 cannot be said to have fulfilled by mechanical compliance of the stipulations made therein. Evidence of meeting the requirement of the aforesaid provision must be reliable. The fact-finding courts did not find such evidence to be reliable. The section 63, my lord, I am just saying. Every testator not being a soldier employed in the so-and-so welfare or airman so employed engaged in emergency shall execute a will and according to the following rules. The testator shall sign and affix the mark of the will, and it shall be signed by some other person in his presence and by his direction. So, my lord, the first testator is to sign that. Then the signature or mark of the testator or signature of the person signing him shall be so placed that it shall appear that you intended thereby to give effect to the will. So and so. Well, that should be near the sign of the testator, by the way. Will shall be attested by two or more witnesses, my lord. That is there, my lord, I am not being. Now, my lord, your losses may now come to paragraph 11. Thus, the High Court are in formulation of the question of law on the basis of the will was probed in terms of section 63 of the Succession Act. Both the fact-finding courts, trial court as well as first appellate court, has found that the will was not probed. The evidence of witnesses was disbelieved as they failed to inspire confidence of the fact-finding courts. The High Court, however, went into a detailed and factual inquiry to come to its finding. We have the opinion that an inquiry of such nature was impermissible while hearing an appeal. My lord, your losses will find, my lord, here that the scribe said that he had prepared a draft of the will in his home. He did not produce it. When he got the instruction from the testator, nothing is there, my lord. Now, other witness said that as per testator, he had prepared the will. And the P2 says, my lord, there was only 3 persons. The presence of Rohit Gusai is absolutely right. And if your losses see the will, my lord, your losses must see the will. Here, my lord, actually, these are the papers, my lord, used for filing Hajira and petitions, my lord. Your lordship got the will, my lord.
Just a moment. Exhibit
One.
That may be copy. Original is kept in the safe custody.
Not be here in the exhibit file. Where is the copy? Huh?
So your lordship will see, my lord, the signatures are very much there. Okay. Photocopy.
Where is that? You have annexed?
I have not annexed.
Who has annexed?
My lord, I have a copy of the will, my lord, if you. My lord, you see that the that's also placed, my lord, in the top, my lord, only. And second page, top and bottom, my lord, just like verification. And the papers, my lord, that is paper which were used in the court, my lord. And the attesting witness signatures are on the left hand side only. Now, my lord, if your lordship see, PW2 in it has said, my lord, that paragraph 3 of the in chief, my lord, he said that will was prepared by Tamal Singh, advocate clerk, at his instruction, my lord, and his brother Rohin Gosai was in good health, mind before that. So he said that it was prepared on day execution, my lord. Whereas, my lord, the Tamal Singh said no, he has prepared a draft in his house. Of the draft. And as per PW2, my lord, only 3 persons were present. And PW3 said he prepared the will on a stamp paper. Whereas the will is, my lord, in the cartridge paper, my lord. And as per PW2, he signed the will as a witness, my lord, before the executor signed. The serious circumstances, my lord, the suspicious circumstances are very much there, my lord. The trial court, my lord, failed to consider anything, my lord. Not consider a single evidence. The lord has seen the finding 2 and 3. He said exit 1 was written by me in 2-3 days prior to execution of exit 1. The draft of exhibit 1 was written by me 2-3 days prior to execution of exhibit 1. How he prepared draft? Whose instruction? My lord, that is very much important, my lord. Because testator, well, the attesting witness, in presence of attesting witness, his instructions will be there. And then it will be prepared, and then PW2 totally said that Rohit Gosai was not there at all. And he was not examined also, because he was not in good terms, my lord. Suspicious circumstances, my lord. So, my humble submission, my lord, this finding of issue number 2 and 3 are liable to set aside, and the the testimony suit should be rejected on this issue also. 2 and 3.
Yes.
Lordship. First point, the answer that testator was not in a fit condition. He has suffered stroke in 2005. So now, if Lordship kindly comes to cross-examination of DW1. He says, in the year 2009, will was executed in 2008. My father gave evidence in connection with another suit. Now, exhibit 3 is his deposition exhibited by PW1 in another suit. That means he was in good sound and health to depose. Exhibit 3 is a certified copy of deposition. Then PW2, he also says that because for purchase of land, he used to go to this testator, and in April 2009, in his deposition, April 2009, by registered sale deed number such and such dated 29/4/2009, he purchased from the testator land, and there is no denial to his cross-examination to that effect. So that he was not, testator was not fit or in good sound and health, it goes. Now, secondly, execution of the will. Question has been raised that PW 2 was only there, one attesting witness, other attesting witness was not there. I beg to refer section 63 of Indian Evidence Act. C, 63C. It says, the will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will, in the presence and by the direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark. So not only seeing, acknowledgement from testator is also enough. Or of the signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time. So both the attesting witnesses are not required to be present at the same time. Only the acknowledgement of the testator is required. So in this case, it has been proved. Now, second thing, only one attesting witness was examined. Section 68 of Evidence Act is clear. Proof of execution of document required by law to be attested. I am just reading the proviso, Lordship. For full. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to process of the court and capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will. So in respect of will is required in other documents, attesting witness is not required. So we have examined one attesting witness, and he said that he saw on the dictation of the testator, it was prepared and read over, and accordingly he signed.
Is PW?
PW 2. And PW 3 is the scribe. He says only confusion, it is a stamp paper or what? In a green paper, it was green. It was in legal size paper. It is there. It is in legal size paper. So his deposition also cannot be shaken by any cross examination. So these two witnesses, PW 2 and 3, is relied upon by the trial court also. Has posed that he was genuine, he was fit in state of mind, and he executed. Will was executed as per his direction. Now I beg to rely upon two decisions. Although Lordship section 68 is clear, one witness is enough.
I am disputing that, my lord. I have not gone to that extent. I have submitted that Rohit Gosai presence was not there. He had not seen this. But it was signed.
But section 63C was not required also. That is my submission.
The name of PW2?
PW2 is Kaur, Subhash Chandra Kaur. One is 2005 to SCC 784. Devi and others versus Jayaraja Shetty.
Trial court. We did not at all discuss any of the cross examination. This much.
Yes, there should have been more
And that-
discussion on this issue. Discuss the evidence prior to discussing the issues.
Maybe he thought that since he was going to this round of limit.
Now, Sridevi Lordship, 2005-1 SCC, paragraph 11. Devi. Others versus Jayaraja Sheikh. Paragraph 11. If I made it. It is well settled proposition of law that mode of proving the will does not differ from that of proving any other document, except as to the special requirement of attestation prescribed in the case of a will by Section 63 of the Indian Succession Act 1925. The onus to prove the will is on the propounder, and in the absence of suspicious circumstances surrounding the execution of the will, proof of testamentary capacity and proof of the signature of the testator, as required by law, need be sufficient to discharge the onus. So testamentary capacity and execution we have proved. Then where there are suspicious circumstances, the onus would again be on the propounder to explain them to satisfaction of the court before the will can be accepted as genuine. Proof in either case cannot be mathematically precise and certain, and should be one of the satisfaction of a prudent mind in such matters. In case of person contesting the will alleges undue influence, fraud, or coercion, the onus will be him to prove the same. So this circumstance has to be proved by them. And my submission that PW2 cross-examination of DW1 and Exhibit 3, it will show that he was in good state of mind even in 2009. As to what are suspicious circumstances have to be judged in the facts and circumstances of each particular case. Well, in the light of this settled position of law, we have to examine as to whether the will under consideration had been duly executed and the propounders of the will had dispelled the suspicious circumstance surrounding the will. Now, my humble submission in our case, there is no suspicious circumstance. Whatever they alleged, it is in the evidence that he was in good state of mind till 2009. And another suspicious this Rohit Gushai was not there. So according to Section 63C, it is not required. Paragraph 14, it says the propounder of the will has to show that the will was signed by the testator, that he was at the relevant time in sound disposing state of mind, that he understood the nature and effect of disposition and had put his signatures to the testament of his own free will, and that he had signed it in the presence of the two witnesses who attested in his presence and in the presence of each other. Once these elements are established, the onus which rests on the propounder is discharged. DW2, the scribe in his testimony has categorically stated that the will was scribed by him at the dictation of the testator. The two attesting witnesses have deposed that the testator had signed the will in their presence while in sound disposing state of mind, after understanding the nature and effect of the disposition made by him, that he signed the will in their presence and they had signed the will in the presence and in the presence of each other. In cross-examination, the appellants failed to elicit anything which could persuade us to disbelieve their testimony. It has not been shown that they were in any way interested in the propounders of the will, or that on their asking that they could have deposed falsely in court. Their testimony inspires confidence. The testimony of the scribe DW2 and the two attesting witnesses DW3 and 4 is fully corroborated by the statement of handwriting expert DW5. The will runs into 6 pages. The testator has signed each of
Facts of that case.
Yes, 6 pages. In this case, there are 2 pages. In both the 2 pages, he signed. In the second page, in the bottom also signed. So another second judgment lordship I submitted to show that as per this one attesting witness is enough, which is in Section 63 itself, it is there. In paragraph 26 of that judgment is there. It is in Dhoniram. So my humble submission is that the suspicious circumstances, what they are saying, there is no such suspicious circumstance. Testator was in fit state of mind till 2009, and in this will was executed in 2008. PW3 has stated he scribed as per his dictation. PW2 says he was present, and as per his testator's instruction, he also attested the will. So, will is genuine, and regarding limitation, I have submitted already, lordship. Perhaps it can be condoned.
My lord, the evidence of PW1, your lordship may see, my lord, that he said that, my lord, he was on bed, my lord. The evidence may be given, my lord, on. My father gave in his construction another suit. I have submitted documents so that my father was buried. Your lordship may see the evidence of PW1.
No, one is the physical part and other is the mental faculty part. Physically, one may be in bed. We are just discussing for the sake of. These
Other things I have shown, my lord, how it is there. Because the two attesting witnesses is a must, my lord, and they must have seen the attestator to sign. So when Rohit Gosai was not there at all, how he can see that?
It is covered by section 63C.
I've also that I know.
Acknowledgement is.
Yes. Sevi.
Much obliged.